Good evening. I'm so glad you were able to find the time to be with us for this evening's United Policyholders Roadmap to Recovery webinar. Um, Tonight, we will be talking about some of the deadlines and decisions that may be relevant to you at the 1-year anniversary that's coming up of the Marshall wildfire. So again, thank you for being with us tonight. If you want to follow along the slide deck that I'm going to be advancing, you can go to uphelp.org and then you go to the events tab in the top navigation. It should, you're actually going to have to go down the page a little bit to find this event, deadlines and decisions, and then you'll see there with the yellow highlight. You click on that and it'll bring the slide deck up so you can follow along if you'd like to. Or you can just stick with me and watch the screen and I'll be advancing the slides. So just a quick reminder about who we are and why we are bringing you this information. We're a nonprofit. We've been around since 1991. And for all that time, 31 years and counting, we have been bringing services to disaster impacted communities and providing education and advocacy services to the general public throughout the United States. We're not for profit, not for sale. We don't take money from insurance companies, but we have a lot of expertise in insurance. We're funded by donations and grants, and we have built up a lot of experience in the issues that come up at the 1-year anniversary of a wildfire. Team Up is our professional staff. Myself, I'm joined by Valerie Brown tonight, and also got some help from Carolyn Winter on our staff. Then, of course, our government and nonprofit partners, our long-term recovery group partners in Boulder, our county partners, our partners at in the towns of Louisville and Superior, and then, of course, the Department of Insurance is a very important partner for us in Colorado, and then our volunteers, which include the people that you can chat with on our Survivor to Survivor forums. We have one tonight right after this program. And then, of course, our consumer-oriented professionals, 2 of whom are here tonight to help us answer your questions. And those professionals include lawyers, public adjusters, CPAs, financial planning experts, construction and real estate professionals, and then people who do restoration, repairs, rebuilding on damaged and destroyed structures. We're here tonight through the Roadmap to Recovery, but as some of you have already figured out, some of the problems that you're navigating in the aftermath of the Marshall Fire can't really be solved just on the ground, and they need some public policy changes. And so some of those changes are what we work toward in our advocacy and action program. So the laws that have been passed in Colorado that make your lives easier, or should, we work very hard to try to help get those laws passed. And then, of course, through our Roadmap to Preparedness program, we try to help people not find themselves underinsured. But of course, I know many of you did try to avoid that and still found yourselves underinsured through no fault of your own. So the library is there for you all the time. We continue to keep it updated. And just a reminder that we're here as educators and to give you general guidance, not legal advice. And if you do have a specific legal question, we recommend that you consult an experienced attorney. And a great way to do that, to find one, is to go to our Find Help directory. And that includes, you'll find lawyers there, you'll find public adjusters. And typically the ones you'll find in our directory are a cut above, because they the reason they support us is because they understand that in the complex world of insurance, the consumer really needs a friend, and that's what we are. So thank you again to our special guests. That's me. I'm one of the founders of UP, and I'm sure if you're dialed in tonight, you've seen this slide before, and you know I've done a lot of stuff having to do with insurance, and I'm an attorney, but not a practicing one. Chris, you may have seen, he's been incredibly generous with his expertise and time. Chris is a public adjuster. He has a decade of volunteer service through UP under his belt. I think our other speaker does as well. He's got 2 decades of expertise in his field, so he's really seen a lot. And he is a big proponent of ethics and good practices in the public adjusting profession. Tom Henderson also has been a longtime volunteer for United Policyholders. He's an attorney who practices again in Colorado. He's gets all kinds of awards, and he certainly gets awards from us for being very, very generous with his time, just like Chris. And insurance and representing policyholders is his thing, his special thing. So thank you so much, Tom and Chris. So just a few reminders, just to recognize that the anniversary of a wildfire tends to bring up emotions and renewed anxiety. It's very normal. So if you start to head into the holiday season and you feel like something's different, something's weird, again, very normal, very common, and you're in good company for sure in your community. But it's a good idea to request from your insurer a summary of all the amounts paid to date, so you have a pretty good picture of where you stand with your insurance claim and what funds are still owed to you. And then once you get that, you want to correct any errors. And then you want to make sure that you're continuing to turn in receipts, both for the reimbursement of your ALE benefits, any expenses you're incurring because you've lost the use of your home, and or receipts for items that you're replacing, so that if you've gotten paid your actual cash value and you want to make sure you get the replacement cost value, you got to keep being diligent with those receipts to avoid leaving money on the table.
Hey,
and then finally,
Amy,
yes,
just want to jump in real quick. Everybody, that third bullet point is really important. I mean, they're all important bullet points, but that third one is particularly important because if you are in an underinsured situation, which I know many of you are, it's really critical to make sure that the payments that the insurance company has put into certain buckets, they put into the correct buckets. Because if they shouldn't have put something into coverage A, but they did, something that should have been in coverage B, or that should have been in one of the additional little mini buckets, additional coverages, if they put it into the wrong bucket, then the insurance company is prematurely exhausting the limits that you desperately need to rebuild under coverage A. So really pay very close attention to where the insurance company is, into which bucket the insurance company has put it. Just because the insurance company put it there doesn't mean it belongs there.
Yeah, excellent point. Thank you for that. And then finally, you want to be communicating with your insurer in writing to get confirmation of all the deadlines they intend to enforce at the 1-year anniversary. And you can see that we've given you links there to 3 publications on our website that will help you. One of them is a sample letter, actually both of them, 2 sample letters you can customize. And this is just sort of to give you a feel for what we're talking about here. You're going to write to the insurer, you're going to fill in their name, the name of the person that you're communicating with, that you understand to be in charge of your claim. You're documenting that you are holding up your end. You're doing your best to document your loss and cooperate with the insurer. It's good to put that in writing, that you're cooperating and that you're being diligent, but that you need extensions. So this one here is just referring to a 1-year deadline that you might see in your policy to submit a proof of loss. And we'll be talking about that in a little later with Chris. And then we'll also be talking about the suit against us. Probably not something you need to be worrying about right now, but Tom will talk a little bit more about that. So generally, insurance policy deadlines vary depending on who you're insured with and what form you have. Some of them are extended by operation of law, such as the lawsuit deadline we'll talk about. And then some may be encouraged by bulletins issued by the Division of Insurance, but that doesn't make them mandatory. So we're going to talk more about the sort of elephant in the room for many people today is if you only have 12 months of ALE and you haven't been able to get back into a rebuilt home or a new purchased home, that's not going to be enough for you. And although the insurance commissioner has done everything he can to encourage, compel, politely threaten insurers, it is within their legal rights to enforce their contract if they want to. And if they decide that they want to be the bad guy and get beaten up in the media, then they can do that. But that, the commissioner, I'm going to show you one of his bulletins saying, be reasonable, extend deadlines, but he has not exercise. He doesn't have the authority to force them to extend your ALE. Although I know he, in his heart and in his mind, he would like to do everything he can to help.
Hey, another real quick point.
Sure.
The distinction between regulations and bulletins, both come out of the Division of Insurance. Regulation, though, is a directive. That's a thou shall do such and such.
Right.
Bulletins are just what Amy's been talking about, which are more kind of strong cajoling, but they're not requirements. Yeah, right. They're definitely shoulds, and they're the type of thing that you can try to use to lobby on your behalf, but they're not thou shalls.
Exactly. So all of these deadlines, though, can be extended voluntarily by the insurer if they choose to. But I can promise you that some of them will not. So that's just the way it is. And you do everything you can to try to fix it. You want to, for now, you want to clarify with your company and your adjuster ASAP, because you got to get these extensions in writing in order for you to rely on them. And I know that there's a number of people that are organizing to try to put as much pressure on their insurers to extend the ALE deadlines. And that's exactly what has happened in lots of other places. In Northern California, we were United Policyholders helped with a sort of community organizing and a rally that went on in Santa Rosa, just to try to really get some media attention to the problem and put pressure on insurers that way. So to do before the anniversary date of your loss, which I believe is the 30th for almost everyone, right? It was a 24 hours, all happened in one day, right? The straight lines. That's
right, December 30th, yes.
Yeah. Sometimes these events go over a couple days, but that one was quick. And then, of course, so you want to seek deadline extensions. You want to ask, right? You want to lay out your best case, why they should give you why there's good cause for them to do what you're asking them to do. For example, if there were delays that the insurer caused or other delays that were out of your control, COVID, supply chain, labor material shortages, weather, illness, you want to write that in your extension request. That's good cause, right? Could be. All right. So insurers will grant deadline extensions a lot more readily than they will extend benefits, right, guys? Right? Okay. So you need a little more time to to collect your RCV, or you need some more time, on submitting your inventory. A lot of the times they'll do that. You want to get them to pay more ALE than they are obligated to. That's a very different story. Obviously there still are some companies that don't have a time limit, or don't have a dollar limit. I don't know, Chris, you see any policies that don't have a time limit?
No, typically it's going to be 24 months for ALE. Is that what you're talking about?
Yeah. I know, some State Farm doesn't have a dollar, right? It's as incurred, but they have a time.
Actual loss sustained, correct.
Right. So those are two different things. But if you are substantially underinsured, review our guidance and consult with an experienced policyholder attorney. But before we get back to the proof of loss, Tom, do you want to just do kind of a thumbnail on underinsured, what you're telling people that come to your law office about whether or not they should undertake a lawsuit for being underinsured?
Sure. And as I know that most of you have who are underinsured have probably already come to realize, it's a very long, steep road to hoe in an effort to try to get a carrier to retroactively, we call it reform, but basically rewrite the policy to say, oops, we didn't do the job we should have done in terms of making sure that you, when you placed your trust in us to have adequate insurance, they're very reluctant to agree to that, and particularly when you're dealing with a loss on such a large scale as the Marshall Fire, because golly, if they do it for Peter, then they're going to need to do it for Paul and Jane and everyone else. The way that I look at these folks is I view it on a spectrum. In Colorado, in order to sue an agent, you have to show that there is what we call a special relationship, and that's very poorly defined. But suffice it to say that your normal everyday relationship with your agent, whether it's someone that is in the I'm going to pick on State Farm here, or American Family, in the office down the street where it says American Family above the door, or it's an agent that doesn't have a specific named insurer above the door, or it's online. But the normal relationship where you go in, you talk to them when you're buying the house, because you got to prove you have insurance in order to close on the sale of the house, the purchase of the house. And then you don't have another lick of communication with them, but you get your annual renewals where, sure, they're going to bump up the coverage incrementally that's supposed to track roughly with inflation. We'll see whether that happens this year. But there's really no further dialogue. What we know for a fact is that is not a special relationship. So for those people in that category, there's really very little chance that you have of trying to convince the insurance company that they made a mistake, or that there was a mutual mistake that would justify rewriting the policy. The opposite end of the spectrum, where there was established a special relationship, is where there is a very specific communication between the person wanting the insurance and their agent that said, I need this type of insurance. And the agent very specifically wrote back and said, I will get you that kind of insurance. And then the policy that the agent delivers to you doesn't include that kind of insurance. The specific case, it's called the Pete's Satire Lounge, for those of you who've been in Colorado a long time, old bar out in East Colfax, little seedy, that wanted liquor liability coverage. They overserved, the agent said, yes, I will get you liquor liability coverage. As you might tell from the story here, they overserve somebody. That overserved person gets on the road, drunk driving, causes a terrible accident. The bar then gets sued. The bar turns the claim over to their insurance company, and their insurance company says, too bad, so sad, we have a liquor liability exclusion. So in that instance, the agent was liable. So where on that spectrum do you fall? That's the gray area. I have certainly talked to some people who purchased their homes only in the year or two before the fire and had very specific communications with their agent about their the amount of insurance, including one who asked the agent, are you sure that's enough? Oh yeah, that's enough. And then they put on solar panels and redid their basement. turn that information into the insurance company. Allstate is the insurance company, and Allstate incrementally bumped up the limit, but still said, no, you'll be fine. So that's someone who is much closer to the end of the spectrum, well, I'll call the Pete's satire, or the special relationship end of the spectrum. So I know, Amy, I probably went on much longer than you anticipated.
That's
Although
okay.
you've known me long enough to know that I'll spout on for a long time.
That's okay. It's all very,
But
listen,
the grim reality, folks, is that for most of you, unfortunately, there's not a great deal of hope. I could talk for hours on this particular topic, but I'll be quiet.
well, I appreciate it. You know, for those of us, and I might have done something wacky here with my screen. Just give me a minute. There we go. For those of us, you know, lawyers, it's underinsurance is very frustrating. It's just, it doesn't feel fair that you could rely on a professional and then they could let you down, and then you could be without a remedy. But they're not necessarily without a remedy. I think a lot of people are undertaking lawsuits and moving along, and you can still think about it, because although, Tom, if somebody is thinking about suing an agent, do they have to worry about the 12-month statute of limitations?
No, that it would be a 2-year statute of
Okay.
limitation against the agent. Basically, it's a negligent misrepresentation type of case. And, you know, just 2 more quick words about this.
Sure.
The insurance industry, this has been a problem that has absolutely nothing to do with COVID. It has nothing to do with labor shortages or supply chain issues. It's been an issue in every single one of these fires that I'm sure Chris has worked on and that I have worked on for UP, and it's been an issue for a long time. It's endemic to the industry. The industry knows full well that it grossly underinsures people. You know, it perhaps the smiley-faced agent on the street corner doesn't really know because they haven't really dealt with it before. But every time there's a mass disaster like this, at least 2/3 of the people are underinsured by a couple $100,000. UP stats bear this out. What I will say is Commissioner Conway, we've gotten his ear, or UP and all of you folks have gotten his ear. There's a real opportunity to make some headway here so that the next people, when the next fire happens, because we know that there will be more fires, that hopefully they won't face the same grim reality that so many of you are.
Yes. So, no, it's fine, Tom, I appreciate it. But, you know, for those of you who want to go deeper on this, we already did a full program on underinsurance, and you can look and watch that on our website. And you still have time to make your decision about whether you want to pursue litigation. Okay, so Chris, do people need to be worrying about submitting their proof of loss at the 1 year?
Oftentimes, the carrier will request a proof of loss and you will have 60 days to submit the proof. State Farm's policy actually says that they want a proof of loss from the insureds within 60 days of the loss. I don't believe State Farm is pursuing that or demanding those right now, since we're almost 10 or 11 months in, but it is part of State Farm's policy where they want it 60 days, but there are many people that probably haven't even gotten or didn't get the rebuild estimate from State Farm for 3 or 4 months after the loss. But each policy is a bit different. Some say 60 days after our request. State Farm's actually says 60 days after the loss. But I don't think that they're demanding them or they're holding people or denying claims if they haven't turned in a proof of loss. I don't foresee them following up either.
Right. So here's that language. It's normally 60 days, but it's one of those things that insurers very often don't enforce, right? But that's why we say if no extensions have been granted and there is that either 60 days or 365 days, you really want to get that just on paper hashed out with the insurer. We agree, the claim's open, keep going. And then
So my thought on that, Aim,
what's that?
if they do say, give us the proof, you definitely want to comply.
Right.
If they follow up and say, please give us your proof, you do want to submit the proof of loss. You do not want to have them suggest that they requested it and you failed to do it, because
And
that
you
would
didn't
be
do it.
problematic.
Can you, I mean, I know with a flood claim, you know, you can't put undetermined, but for a residential claim, you could say, you can say approximately, or say, you know, still being determined, right? But as long as you actually physically get a proof that says I have a claim and I'm making my claim, that's better than nothing, right?
That's correct. You can do a partial proof. Just follow, usually it's a standardized form, and you can
Right.
fill in the information, but as to the amount of the loss, and if you don't know it, you can put undetermined at this time, but you
Right.
still only want to comply with the policy.
Right. Very good. Okay. So the limits that matter, this is just a summary, how long your ALE, temporary rent benefits are payable. The default for years and years had been 12. Your legislature said the insurer was supposed to offer you 24 months at the point of sale. So that's something that some of you may have an issue if you only have the 12. Do you have any evidence that you were offered the 24 and turned it down, or do you not remember? Have you had that conversation? The other limit that may matter, how long you have to submit your receipts to collect your replacement value over the depreciated value on your contents. And then the third is how long you have to collect full replacement value on your rebuild or your home replacement. So again, in a lot of situations, the insurer may be responsible. You heard Chris say that maybe the insurer didn't even get you their estimate for 3 months. So unreasonable delays in responding to your communications, unreasonable adjuster requests for information, may basically making you do the same thing 3 times, submit the same proof 3 times. Shifting of responsibility onto your shoulders to adjust the loss when it's really their job. Rotating adjusters that required start overs. And, you know, some people have said, oh, I have a voice recording from my insurer that I saved where they said that they just are so overwhelmed that they can't deal. And that's the kind of thing where you say, look, you know, we understand you have challenges, so do we. So let's work together here. These are some of the bulletins that the department has put out that may be helpful to you. And you can read those on their website. This is just a recap of Colorado law. And by the way, the Q&A bar, when you see your Zoom bar at the bottom there, you see Q&A. That's where you can be asking questions. And if we haven't answered them in the Q&A, I will be reading them out loud, and our guests will be answering them. So this is just a recap of what the law is in Colorado. We've already talked about a lot of these things. Chris, on RCV, what do you see in most of the policies on collecting the balance between the depreciated amount you were already paid and what you are entitled to?
Right. So for the dwelling in the rebuild, or if you're purchasing a property, you have 2 years from the date of loss to collect the RCV benefits, or they ask that you complete the repairs within 2 years. For contents of personal property, you have 3 years to collect the recoverable depreciation. So right now, those in the Marshall Fire have to, I think, 2024 to get their RCV benefits. If they don't submit them and request them, then they would only be paid on an ACV basis.
Okay. So Keith asks, I understand the 12-month limit for contents to get replacement value, but I'm wondering if that applies to things like window coverings that are part of the house. Do I need to get a specific extension for window coverings? I guess they mean until the house is built, they don't know what kind of curtains they need or that sort of thing.
So my take there would be that would be part of the rebuild estimate. And that would be part, if you're having a general contractor, that cost would be captured within the rebuild estimate, and you would have 2 years to complete the rebuild. Okay.
We got just a general question to explain what a proof of loss is. You want to take that, Chris?
Sure. Proof of loss is it's defined in the policy. So under the conditions section, it'll talk to about your duties after a loss, and it basically says what's the date of the loss, who's the carrier, what's your address, when did the loss happen, and basically wants you to say, here are my damages, here is my loss. And it's very difficult for anybody to come up with within 60 days. But at this point in time, 11 months after, you might have a good idea if you've completed your inventory of personal property and you have an accurate rebuild estimate. Those are primarily what you're looking for to capture as your proof of loss, that you're telling the carrier how much you want them to pay.
So, yeah, I mean,
and let
I
me,
know in California, one sec, Tom, I'll get to you. We actually passed a law that said, it doesn't, the proof of loss, that the insurer has to accept a proof, even if it isn't on their specific form. But you know, most insurers they actually have a form that they're supposed to give you. That's part of their obligation, is to provide you with all the necessary forms to do your claim. That doesn't always happen. Tom, what were you going to add?
yeah, what I was going to add is actually the full term, or the full title of the document, is a sworn statement in proof of loss. And the swearing part of that is that at the bottom of the form, you are swearing and affirming that the statements are true and accurate. And the insurance company uses that as a weapon to try to get you to go, what a lawyer might call, on the record, as stating, here's what my loss is. So it's not something that can just kind of be willy-nilly filled out and completed. It's something that you'll need to give some thought to. And also, if you are feeling pressure to complete something, but you simply don't know, then you can handwrite, or with a PDF, you know, once it's OCR'd, add in the word partial in front of it. The insurance company won't like that, but tough beans, just write the word partial in there, because that's a way that you can CYA.
Yep. Okay. We have a question here. Do all policies have to include the minimum 12 months ALE, or are there cases where it cannot be included and still within the law? I know in California, where there's this standard form fire policy in the code, it has that language, but do you have that, Chris, in Colorado? Is there any requirement that a policy contain ALE coverage?
Well, I'm going to defer to Tom on the legality, but I believe that there's ALE is in every policy, and you must have those benefits. And I'm thinking that it should be 24 months. As to whether or not legally, I defer to Tom.
Yeah, I'm double checking right now in my little Colorado revised statute. So I will continue to double check and answer the question. I don't think I've ever seen a policy that does not include ALE. So if one does not, then there's a big problem there that might interest a lawyer. But I believe with the Homeowners Insurance Reform Act of 2013, that UP, by the way, played an active role in shepherding through the legislature, that it is required that there be 2 years, or at least 2 years are offered. I have certainly run into a couple of Marshall Fire people who say, well, hold on a second, my policy only has X, and I don't remember if that's ALE or if that's extended replacement cost, but I know that their policy didn't have what is the mandatory minimum requirement that be offered in Colorado. It doesn't mean that you can't take something else. And so those people, I think, were going to go back against their agent, and I think their agent was agreeing to reform, and because they didn't include whatever that minimum, they got less than what they were supposed to be offered.
Yeah. Okay, good. We got a few more good questions here. For people who have rented, although I'm not trying to understand this one, but one of you guys might. Also, for people who have rented out their property, can we also have extension of rent, just like ALS? So I'm assuming ALS is one of those temporary housing providers that they're, right?
Loss sustained.
It's probably ALE.
Oh, actual loss sustained. I'm sorry. Okay.
Well, from my perspective, the rules that are written into Colorado law mostly are about homeowners insurance and owner occupied insurance or dwellings, as opposed to landlord coverage, basically. But I know oftentimes for a landlord's policy, it's not called just living expense, rather it's called lost rents coverage. And you can certainly try, but many of these kind of consumer-oriented laws that are designed to help people who don't have a place to live are really focused on the homeowners coverage and not the landlord coverage. So I think it's probably a more challenging task to get an insurance company to agree to extend lost rents.
Yeah, this
Still
person
try.
clarified, for rented properties, can we extend the standard period for the insurer to pay the rent? I think you answered that. Is that, or Chris,
My
I'm
take
sorry,
on
you're
that
on.
too is, well, so we're seeing where there are some homeowners that have a primary residence and then they have a rental property. And in the rental property, if the carrier hasn't timely adjusted the claim, and the policy basically says you get 12 months of lost rent, here we are 11 months in,
Right,
and they haven't adjusted it. The carriers have kind of delayed a proper resolution, and now the policyholder's up against a deadline where they're not going to receive the lost rent anymore, but the home is either, partially damaged and it still not repaired, or it's not been rebuilt. That is problematic. And again, if the delay is caused by a carrier not properly adjusting the claim or not responding to your estimates and the like, it is reasonable to request an extension. However, the policy says 12 months. Whether or not you get the extension may be a little more problematic, but I think it's reasonable to request it.
yeah. So Keith just wants to share a point of information. Thank you, Keith. I want to let folks know that I had to follow up with my agent to get confirmation that I did have 24 months of ALE and no dollar limit, because it was a separate endorsement that they did, because while Colorado had that requirement, other states did not. So my understanding of Colorado law is that that there's lots of 12-month policies out there now, but the law that we helped get passed in 2013 said that your agent was supposed to recommend or tell you that 24 months is available. And of course they should, with due diligence, say 12 months is proving impossible for most people. It's not realistic. But I think a lot of people don't have notes from when they had their communications with the agent. But there's lots of arguments on the 24 months, such as the law has changed, that they really, if that I should have been offered the 24 months and all that. Wanda is asking, are dates from the fire 12/30/21 or from when the county declared the home destroyed in January? My home was still burning on January 1st. So we talked about this a little bit, but we have a question about, what do you think? Either of you? Tom, let's start with you.
Well, from a lawyer's perspective, I always think better safe than sorry. So yes, it sounds like you may have an argument that it really shouldn't happen from December 30th if some of the damage still happened on December 31 or even January 1, assuming they're still smoldering and that sort of thing. But in terms of the so-called date of loss that triggered the need to replace the dwelling, most of the time, I think it's probably going to be interpreted as December 30.
Yeah.
So that would be the safe way to go. Why risk it and live to regret it?
Right.
Well, and at this point in time, the carrier would have identified that for that particular homeowner. They would tell you what the date of loss is.
Yeah, you would think that the correspondence should say date of loss, and then all right. Alan is asking if you've submitted your contents inventory. He submitted his on July 3rd, and it has been submitted to management for review November 4th. Well, they took their time there, which seems like a very long time for the adjuster's review. And we've not received any questions yet. And then State Farm reduced the value of our items. Does the time for responding to their queries automatically get extended? So, oh boy.
I think you have plenty of time to respond to their response to your inventory. They, just because they say it or submit it to you doesn't mean that that's the final word or what they've done is correct. It's just a supplemental ACV payment to you, and you're able to address discrepancies that are not in your favor if you can support the replacement cost that you submitted in a proper depreciation.
Right. So, thank you. So back to Colorado law, we've got, the law. So even, and I know it can be confusing, like a proof of loss versus an inventory. It's, proof of loss is sort of, we've kind of established that if the insurer hasn't given you a specific form, you can just say when you're clarifying with them before the anniversary, what deadlines are there that I need to be aware of. There should, that is the minimum, is the 365 days to submit your inventory. Same thing, you get 365 days after your ALE expires to replace and recover depreciation. But again, that's something that a lot of insurers are extending. So
Hey,
this is,
Amy,
yeah,
I found the answer to one of the earlier questions, so sorry to
no, it's
interrupt.
fine. Good sleuthing.
As part of that Homeowners Insurance Reform Act of 2013, in Colorado, all homeowners insurance replacement cost policies for a dwelling must include additional living expense coverage. The coverage must be available for a period of at least 12 months and is subject to the other policy provisions. Insurers shall offer policyholders the opportunity to purchase a total of 24 months of ALE coverage and give the applicant an explanation of the purpose, terms, and cost of this coverage.
Yes. So thank you. So, and there it is. So there it is. And that is the law that this is the law that applies to all of you. This is the first round of reforms. And you can see that also at the point of sale, your insurer was supposed to offer you 20% extended replacement to at least 10% for building code upgrades and the 24. So if you have some understanding that they didn't, then you have additional leg to stand on for getting what you need. So the law that got passed and took effect this year, that's not retroactive to you, but you can still reference it as the legislature's intent. This is what the elected officials in your state have said to insurers. This is how they expect them to be adjusting claims. Now, it technically doesn't apply to you because the law is not retroactive, meaning it only applies to claims that arose after it became law. So, but these are the requirements. And I feel like the 24 months is, it's an argument, right? It's a very, I mean, that is the law now. It wasn't at the time you lost your home, but I think it's a very strong argument to use. And that goes also, the new law says you have 3 years to collect your replacement value above ACV. Again, this is a should for your insurer. It's not a must, unfortunately, but that's just the way the law works. Same thing with the legislature has clarified that you can use your rebuild benefits to buy instead of rebuild. You had that right already in case law. It just wasn't in the statutes, all right? And then the right to use your other structures benefits towards your dwelling. But I Chris, do you find that insurers will let people do that anyway? Use their other structures money towards the purchase of towards the reconstruction of the dwelling?
Absolutely. So whatever payment has been issued by a carrier, whether it's under the dwelling or the other structures, the homeowner is free to use that as they wish. But if they use it for the other structures, they may not have enough money to then build the detached garage that they had before either, right? So,
right.
It depends. Each situation is a bit different, but yes, they have the ability to use the funds issued by the carrier as they determine best.
Yep. Okay. And of course, a lot of people use their contents money to fill their underinsurance gap, painful as that may be. All right. What are some of the common conflicts that people encounter? Nothing that none of you haven't heard already. People that that you're not going to be able to move back in before your ALE runs out, that you can't replace all your contents and collect RCV until the new home is ready, and what furniture is going to go where and colors and all that other stuff. getting the insurer to pay for code upgrades that would have been necessary to replace the as was home the way it was, getting the insurer to pay the full amount of what it would have cost to rebuild, but instead let you use all of that money, including your code upgrades and your extended replacement benefits, toward that purchase. That's something that the legislature has clarified going forward, but not retroactively. So on code upgrades, this is a big problem. A lot of people find that their adjusters are not familiar with the local codes, and somehow the burden ends up on you, the property owner, or your representatives, if you're working with a public adjuster or a lawyer, to dig and find out what code upgrades, or your contractor really, what code upgrades would you have to make to the original structure. I know a lot of folks, because they were underinsured, went to the towns of Louisville and Superior and asked if they could be opt-outs. They did give that accommodation as to like some of the energy efficiency codes. But again, if the code's on the books and you've got the coverage, and you want to comply with those codes on your rebuild, then it shouldn't. If your insurer comes back and says, "Oh, well, they're not enforcing that," the commissioner has said, "No. He's put out some clarification on this." But the bottom line is that if, as long as the code's in force, and you have not opted out, then you're entitled to those the costs from your insurer if you have that coverage. Okay, anything either of you want to say about that before we move on to replacing by buying? Code upgrade stuff, Chris, anything you're running into?
No, agree with you. So right now, very few are actually able to move forward with the rebuild, and a lot of people don't know just yet what those increased costs for code are, but they might have a good idea. I think that your architect and your general contractor will be working with building officials to determine what those are. And rather than risk it, you're going to have your contractor tell you what they are, so you can share those with your carrier in advance, so there are no surprises, and then you'll get that reimbursed after that cost is incurred. But there should be no issues if you're working with your general contractor. They identify them and you submit them in advance to the carrier.
Okay.
And the point of the regulation, or one of the points of this emergency regulation that Commissioner Conway issued, was if you're not in that underinsurance situation and you're able to build back completely, and you still have enough insurance when you add in your code upgrade and extended replacement costs, that just because Louisville and Superior are not or are granting exemptions for Marshall Fire folks, the insurance company can't turn back to you and say, just because you want to comply with all the code when you don't have to, we don't have to pay you. No, that's not the way that it's going to work. That you're still the insurance company still must pay you, so long as that code could be enforced against you if you chose not to opt out.
Yep. Okay. All right. Whoop. Here we go. I've done it again. I've done it again. All right, there we go. Your insurance. Oh, I'm sorry. We have a question related to this. I wanted to ask. If Steve asks, if you get a waiver on a code upgrade, does this set up a situation later in selling where the buyer has to catch up on existing codes? I'm going to say no. I'm going to say you buy it as is, right? Does the buyer have to bring it up to code? The only time is if you were to start doing a remodel, you buy it and you do a remodel and you got to get a permit for the remodel, and then they see that it's not to code. But if you buy a house, you buy it as is. The building department has nothing to do with that. Is that, you guys agree with that?
Yes. It might become part of the standard negotiation between buyer and seller after the potential seller's home inspector comes in and spies a certain alleged deficiencies, but then you're negotiating that either out of the purchase price, or you're going to jointly fix it, or the deal goes south. So,
Right, and Steve asked a follow-up question. How about as an owner and you want to remodel later, then you have to catch up on code. It's the same thing. Anytime you apply for a permit, you open yourself up to an inspection by the building department, and if they find things that are not to code, it doesn't matter whether you're selling or you own it, whatever, they're going to make you bring it up to code. I see Chris nodding.
Yes,
Okay.
agreed.
And then another related question, well, actually, Alan just is noting a future buyer might find your house to be less attractive because it wasn't built to the latest code. That true dat. Okay. Wanda asks, I'm not sure I understand this question. One of you might. If I want code updates, can my insurance limit reimbursement on same? So I'll take a crack at this if they think I understand it. The way that the policy is written is they pay for what was, right? Not what they would call betterment, not improvement, right? They insured what was. So that's why if you have this building code compliance coverage, it pays for the betterment. But if you didn't buy that coverage, because it's usually an add-on, an endorsement, a rider, something you pay extra for, then yes, they can say, we're not paying for that because it's betterment. Anything either of you want to add to that?
what I would add to it is this goes back to one of my original comments about the buckets.
Yep.
This is one of those buckets that if you've got the money that you can allocate toward code upgrades, then allocate it there, which allows you not to prematurely exhaust your coverage A. On the other hand, if you're going to tap out your 10% or whatever it is code upgrade coverage, but you still have a little bit of money left under the coverage A, there also is an argument that you can make pursuant to a specific case in Colorado that coverage A really ought to come in and pick up that part of it, even if you don't have enough coverage under the code upgrade.
Right. Okay. All right. So let's just talk briefly about your rights related to buying versus rebuilding. So a lot of people who lose their homes in wildfires just don't really want to deal with a construction project, and they want to replace their home by buying. And like I said, there's been case law now for quite a few years that says you can, but insurers, it can be an argument, right? It's now been codified, right? It's one of those rights that Colorado people now have, but not at the time of your fire. So again, it's one of those things like the 24 months and the 65% of contents without itemization, technically not available to you, unfortunately, but is a point of argument for you, right? So we have been telling people in states where the law is not clear that you can use your best efforts to calculate what it would cost to rebuild the house that you had in compliance with current building codes, if you have that coverage, and get that number, try to reach an agreement with your insurer on what that number is. So if I were going to rebuild, you, insurance company, would have to pay me X. Therefore, agree to give me X, and so I can buy a replacement home. So you're not losing any money, insurance company. You're going to pay the same. It's the same. What you're going to give me, the same amount of money that you would have paid if I rebuilt, that you're going to give me if I'm buying. So let me do it, even though the code doesn't give me that express right. Then you look for a home in that price range, you give the adjuster the documentation, and you try to settle. That's the ideal. In reality, there can be all kinds of obstacles that an adjuster can put up, such as, oh, we won't allow you to do that, such as we're going to deduct the value of the land under the home, such as we don't agree with you that we would have owed you X. Those are some of the snafus, but a lot of people have been able to negotiate their way through this. So Tom, any comments you want to share on this point? Have you had to help any clients through this?
Yeah, the key is document. In other words, get an estimate or a quote from a builder about what would it cost to rebuild what was there. I certainly talk to a lot of folks, as I'm sure Chris does, who say, well, I don't want to rebuild what was there. Why should I do that? I want to build a ranch instead of a two-story. I want to, whatever it may be. The insurance company, you need to define the parameters for them. The parameters are, what would it cost to rebuild what was there before? Doesn't mean that you are not required. I had somebody ask me this just last week. Am I required to rebuild exactly what was there before? No. But the insurance company doesn't owe you any more than it would have cost to rebuild what was there before. Doesn't mean, or you can spend that as you choose.
Okay. Chris, anything to add on this question of you don't want to go through rebuilding, you want to buy?
Yep. So I firmly believe that homeowners have the option to rebuild at the same location, rebuild at a different location, or purchase something. But most importantly, each homeowner needs to know what their claim is. So before they make that decision, they need to know what it costs to rebuild their home exactly as it was the day of the fire. That's your claim. And then, as Tom said and Amy said, do you have the opportunity to rebuild something different? Absolutely. But don't muddy the waters by suggesting or providing something to the carrier that is different than what you had. Your claim is your claim. That's to rebuild it as it was. I firmly believe, even though maybe it's now codified, that even at this point, people do have the option to, the policies typically say you repair or replace. Replace would be buying something different. Right. So can you buy a different home right now? Absolutely, you can. But before you do it, you need to know what the cost to rebuild your home was. Right. Then you can make an informed decision.
Right. And we often refer to it as the as was price. We'll say that was the as was price. Okay. Making everybody dizzy here. So some of the this is the law that got passed and was effective this year that again, not technically available to you, but conceptually available to you, argument wise available to you, right? That they can't hold back, excuse me, code upgrade benefits. They can't, because you're buying, right? That they can't hold back on extended benefits. But again, this is just an argument for you because technically it, I'm so sorry, doesn't apply. Same thing with the land value deduction, that they're not allowed to do that anymore. But at the time you lost your homes, they were. So it's just an argument you can make. And now we're going to all relax our shoulders and take a deep breath and head into the home stretch of the program. Okay. Knowing your rights. This is just a reminder that there are 4 primary sources that dictate how your insurance company should behave. Your state's insurance laws, the Colorado Insurance Code, the judicial opinions, the cases that people like Tom use that are also law, then the regulations and the bulletins that the insurance commissioner's offices put out, the language in your specific policy, and then something called the covenant of good faith and fair dealing. And that is something that the law reads into your policy as if it were written right in black and white, that the insurer has to act in good faith and deal fairly with you because of the special nature of insurance. And so these are some of the regulations that that apply to insurance companies in Colorado. And these are the unfair claim settlement practices. So these are some of the things that that they're not supposed to do. And if you have instances in your claim where they've been doing these things, when you call it out to them, when you create your documentation, when you speak up, as we say, and are being politely assertive, you want to cite specifically to these regulations and say, we have that one highlighted. You know, you you made a snap, say they made a snap judgment on something. That's not a reasonable investigation. You know, like you didn't consider something, they didn't consider something you provided to them, or they took 6 months, you know, to sit on your estimate, and then which made it really hard for you to move forward and get back into a home, and then you ran out of your ALE. Those are some of the arguments, right? That you can make if the facts bear it out. So these are some more of those regulations. You know, basically this is fancy lawyerese for saying no lowballing. You know, don't try to settle the claim for less than you owe, right? And then one of the there's some really good laws in Colorado. You know, one of them is that your insurer cannot force you to have your property repaired by a specific individual or entity. You know, I just taught a class for people in Florida where Hurricane Ian and now Nicole. And, you know, somebody sent me a policy from an insurance company that says, you have no right to pick the vendor the contractor that's going to do the work on your home. And we gave you a 5% discount as a trade-off for that. And that would not pass muster, I don't think, in Colorado because of this law, right? They can't require that repairs be done by a specific business. They can't make you take your stuff far and wide to get it fixed. Here's another rule that you may not have been aware of, that is a bulletin, and it is that your insurer cannot deduct your contractor's overhead and profit in addition to depreciation if you're not repairing or replacing. It's something that you, if you're having an issue with the insurer trying to take out overhead and profit, or depreciating overhead and profit, it's a little confusing. Chris, do you want to say anything about this?
Well, to me on this one, it wouldn't probably be too applicable on people that had total losses, because you're either going to repair it or you're going to buy something. So you're going to get your RCV. This may be applicable on if you have a home that is partially damaged and you do certain repairs, but maybe not do all of it. Maybe they withhold something, but there's certainly communications that can be made with the carrier to get the full replacement cost value.
Yeah, I think we actually had a partial loss question. I think somebody might have answered it. Yeah, Tom, you answered it. Okay, so we'll move on from this one.
One thing on that real quick. I have seen it before. Frankly, I've seen it more in commercial property cases than homeowners cases, where the carrier produces its replacement cost estimate, and then they include contractors' overhead and profit, as they should, but they then when they're making the ACV payment, they just redline through the overhead and profit. And what that bulletin says is, no, you're not supposed to do that.
Right. So this one here, I thought was what I was looking for. That I know the commissioner put out a bulletin that says, basically ensures you got to be realistic about the pricing in the area, and you can't just base your offer on an exactimate estimate that's not realistic, that you know, prices the work out in a way that no contractor would be willing to do, you know, that's not realistic. But I think this is more promptly pay. This is more for repairs, would you say? Less the deductible policy, no less than the prevailing competitive market price, and the same. Would this apply to repairs and replacement?
Well, what we're seeing is State Farm is an example again where they are not using current pricing. They will prepare estimates using December 2021 or January 2022 as their price
Right.
list.
Right.
So the pricing is not proper. The scope is likely not proper. We're seeing that they're not adding architectural engineering fees, supervision fees, permit fees, all which impact the cost to rebuild. And that is your claim. That is problematic. Those are the issues that we're trying to address with them right now. But yeah, they should be open to at least revise their estimate if they gave you one in early 2022 using an old price list. What does it cost today? Because those prices aren't in effect right now.
Yes.
It's not an
And
accurate.
you may end up in a arm wrestling match with your insurance company over what's the proper date to use to determine cost. The insurance company will always say, no, it's determined on the date of loss. Well, excuse me, but you didn't get me your estimate. I just about slipped out some bad words there. Get me fired up when I talk about insurance companies. But you didn't get me the estimate until June.
Right.
So don't tell me that I need to be wedded to a December 30 or a January set of price lists.
Yep.
Even if they did get you their original estimate, most of the time, at least by the time a lawyer gets involved, most of the time the insurance company will capitulate, will kind of relax on we're only going to price it based on January or December pricing, but but be sure and push back if they insist on old pricing.
Yeah. So Steve is asking, if the insurance company ends up with an estimate that exceeds your limits, does this make it moot to discuss that their estimate was not at current market costs?
Not necessarily, because to me, you want to know what the true measure of your damages is. Just because they get you to your policy limits, maybe you have a casualty loss, but you want to accurately determine what it costs to rebuild your home and your other structures. That they may only do it at the limits, that just basically assures you that you're going to get your limits, but that's truly not an accurate measure of your damages. I think that you want to know what it would truly cost.
I agree. We always tell people, whether you might end up applying for a loan, SBA loan, or anything to fill the gap, or you, for your taxes, it's still worth knowing how underinsured you were and what the true, or I should say, put it differently, how much your home should have been insured for. It's still worth doing that exercise. Now, somebody, anonymous asks, can the cost to get that rebuild estimate be part of the payout if I'm required to? I think this person, trying to avoid more out-of-pocket expenses. So this is one of those tough things, United Policyholders preaches the gospel of scope of loss, that it's really valuable to get, the scope of the work that would be required to have put back the house that you had. And then also the numbers, the dollar figures, but the scope, right? How many linear feet of, this and that carpet and what grade carpet and all that stuff. That's the scope, right? So we often say earlier in this series, it may be worth paying somebody out of your pocket to get that estimate, because, real life builders typically don't break out their estimates as detailed as insurers want them to be. And that's why insurers use Xactimate, which of course most contractors don't price their work that way. But in order to get a settlement with your insurer, it can really be helpful to have that level of detail. Sometimes, people end up paying $4,000, $5,000 or more. So Molly, I'm sorry, anonymous is asking, can I try to get my insurer to pay for that? Any response here?
So my thought would be, you're not going to get the carrier to have somebody else tell them how their adjuster's estimate is woefully inadequate. I believe it is a cost that you will incur on your own, and I would highly recommend that you incur that cost. Now, if you have a general contractor, they'll probably prepare that estimate for you as part of the project that they're rebuilding your home. They'll do that for you at no cost. But if you're doing it because you want to know what the value or the true cost is to rebuild, and you don't want to rebuild and you might purchase something, it's still valuable to have that, because you're going to You'll then know what the difference is. And the individual that is preparing the estimates on behalf of the carrier is likely not a general contractor. They know the Xactimate software. They're not going to rebuild your home, and it's likely not accurate. You want to know, and you want to spend the funds necessary to get an accurate estimate, so you know what it costs to rebuild your home.
Yeah,
I
the
don't-
only other thing I'd add to that is occasionally, and you may not see it very often in homeowners policies, but occasionally there is an additional very small bucket of available coverage for like loss adjustment expenses or expenses, and it might only be like $2,500 worth of coverage, and they'll say, we're not going to pay for a public adjuster, we're not going to pay for a lawyer. But if you can get the insurance company to agree that what you're talking about falls within that very small bucket, then you might be able to get the carrier to pay for that.
So that's a loss assessment provision in the policy. And you would want to ask them upfront and in writing whether or not they would do that for you. That's a valid point. Follow up with Amy if you get them to cover the cost, so she can share with others.
So that's another one of our long-term projects, is getting insurers to pay for claim prep expenses in on residential claims like they do on commercial claims. So Wanda asks, how do we get the insurance company to describe how they calculate depreciation? Well, again, this is one of those things where the law now is that they have to, but technically at the time of your fire, they didn't have to. But I think, to me, this is one of those things where I would be amazed if the insurance department couldn't get that out of them, couldn't help you if you were to file a request for assistance. I couldn't get the insurer to tell you how they calculate their depreciation. Any thoughts on that, Chris?
Yep. So oftentimes, if you get the Xactimate estimate, they will show you the replacement cost, and then they will have gotten from the homeowner the age of the various components of the home. So how old was your roof? How old were the windows? How old was your flooring? How old was the carpet? When did you last paint? And they take that information, and it's by years, and that's how they apply depreciation. So you will see it in the Xactimate estimate. You'll see the replacement cost. You'll see a column that says age, and then you will see the ACV. The amount that they withhold, that's the depreciation, and they determined it by the age of the components. And they would have gotten that, or should have gotten that information from you, unless they're just winging it. And you would have the opportunity to review that and provide input. If you did a remodel and they said something was 15 years old and it's actually a 1 year old, you can verify what the ages are, and you should look carefully at their estimate.
Yep. Okay. Alan asks, State Farm has told us they'll revisit the costs when we have a contract. They've not included architecture and permit fees. However, if the prior house was a production build, do they owe me for architecture fees?
Yes, they're going to owe you for architectural fees because you would need them to rebuild. Even if you didn't have it before, you're going to need it now.
Yep.
And so you're spot on. And this is the very issue that we're seeing on many of the State Farm homes. They may capture entries for architectural engineering and permits and that'll be an open item, but they certainly have the ability to provide estimates for those, much like if you were to go to a contractor and ask them, they will estimate those costs. And as long as they're reasonable and defendable, the carrier should capture those costs as well. But we're seeing that they aren't. And just as Alan said, they will say that they will revise their price list if you give them a contract. There is nothing that should be contingent upon them properly pricing the cost to rebuild your home. But that's what we're seeing. State Farm will say, give us a contract with your contractor, then we'll revisit everything and we'll pay you if you incur those costs. But we don't need to include them, and that's not accurate.
Right. Okay, thank you. Anonymous asks, we are underinsured, building a smaller house. Are there any pitfalls we should be aware of for accessing our extended benefits and ordinance and law coverage that we need to be aware of before the 1 year anniversary?
I don't believe so. I mean, if you're looking at the code bucket again, your builder is going to identify what those increased costs are, and you will get them up to the limit as long as the codes are required, and then you incur those costs. So if your builder shares those with you and you share them with the carrier, I don't foresee an issue. Code bucket is different than being underinsured. You still get the limit up to your code amount. If you're underinsured, I'm not sure what anybody can do about that.
Yep. Lynn asks, my insurance company accepted a rebuild cost of $900K. I bought a replacement home for $750K, and the insurance company is calculating, is trying to deduct the land value from the $750. Should they use the replacement cost of $900 less the land value? Oh, that's a tough one. So our feeling is they shouldn't be deducting the land value at all. And we have arguments about it, that it's that it's not that they, first of all, it's not authorized in the policy generally. If that you can say to them, Lynn, show me where in the policy it says that you get to deduct that. We also have a whole set of documents, educational materials about this, but I don't think that I don't think there's not really an argument that the land value gets deducted from the 900. I don't know. Do you guys, either of you guys see that?
So my 2 cents, Tom, is the policy says they don't cover land. That's specific in the policy. So there's an argument where the carrier, at least right now, under the law that existed at the time, they do get to deduct for land, and they have. What they shouldn't do is try to creatively change the value of the land that is different than like closing documents. Because if somebody purchases a home and the value of the land is reflected in that purchase price, that's what the carrier should be looking at, not a number that is greater than that to deny the policyholder benefits, which we've seen. That's improper.
And I agree with that. I mean, Chris is right. Every policy includes an express provision that says we do not insure land. And that's the hook that they typically rely on to make the argument that Amy pointed out, that under the new law, they won't be able to make that argument anymore, but they will still continue to try here. But would it be appropriate for the carrier to use the 900, deduct the value from that? No, I don't think so. If you spent $750 to replace, and I'm sorry, I don't have your question up on my screen. If you spent $750 to replace, as far as I'm concerned, that's what State Farm, I think you said was the carrier, should owe you. But if you're going to try to get more than the $750, that unfortunately is probably, you're not going to be able to do that, because that's an as incurred type of loss or coverage. So if you only spend $750, even though you could have spent $900, then the insurance company saves themselves $250,000.
Right.
But what's very important, sorry to interrupt, Aim.
No,
what's very
it's
important
fine.
is you need to know, regardless of what you spent for that, you want to know what it truly costs to rebuild. That's still your claim.
Right.
So the carrier needs to recognize, so the carrier, if they incorrectly provide you an estimate, or provide you an estimate that does not accurately reflect what it costs, that's the value of having somebody prepare an estimate that establishes that. But if the carrier acknowledges that your loss exceeds the limit and will pay that, then this instance, they should pay you your limits and you're done. You've already incurred the cost now. So if you
Right.
purchase that home, you've incurred that cost.
Right. I mean, I think this is, now that I'm sort of thinking this through a little bit more, I mean, if they're going to deduct land value, arguably they should deduct it from the 900, because if that's what they would have owed them, right? I mean, the whole thing doesn't make sense to me anyway, because my feeling is, if you're buying, let's say your original home would have cost $900,000 to rebuild, not including the land. Okay.
Yep.
That $900,000 doesn't include the land. Then if you go ahead and buy a house for $750,000 that includes the land, you've already bought a house that's less valuable, considerably less valuable. right? 900,000 plus the land, 750,000 including the land, it's much less valuable. So the person, the entity making the windfall here is the insurance company. So that's what's always bothered me about the land value thing. It's like they're not getting, it's not like, you know, she's getting suddenly getting unjustly enriched because now she has 2 lots. And, you know, yeah, she has the old lot. That's also part of their thinking as well. You still have the old lot, you can sell that, right? So anyway, it's a fight, and we hope that you prevail, because I think, again, to me, logic is on your side. That you know, that it is not that it is what you purchased is not equal in value to what they would have owed you had you rebuilt. Okay, so let's see. Alan asked, if they don't insure land, how can they count the value of the land in the policy benefit? If the policy doesn't protect the land, then the policy benefits must only be for the structure. Where's the logical consistency? I mean, that's kind of what I'm saying. It's like, if they would have paid you 900,000 had you rebuilt, then where do they come off deducting the land, right? It doesn't, to me, the logic isn't there. But anyway, all right. So we are going to have to wrap up here soon. So Rick, yes, it does seem like you need an extension. Rick submitted their I assume it's contents inventory August 31st. They haven't gotten anything back. I think you meant the adjuster said that that they're behind. That's a perfect situation to ask for an extension. Anonymous asks, what's the process for filing a claim or complaint against an agent's E&O coverage? Is this a path you've seen successfully navigated? Tom, you want to hit that? I mean, yeah.
I'm sorry. I was reading somebody else's question.
That's
so
okay.
Go ahead.
The question is, oh gosh, where did it go? Where did it go? Come back. Here.
They want to know how to
process
pursue
for
it.
filing? Yeah. What's the process for filing a claim or complaint against an agent's E&O coverage? And is this a path you've seen successfully navigated to address underinsurance?
So the path to doing it is you need to hire a lawyer who has some experience in that area, and probably the lawyer will write a demand letter to the agent first. The agent puts their own errors in a malpractice carrier on notice, and then you off to the races in terms of litigation. If you have a strong claim, then the claim might be settled, but they are tough claims to win. I tried once and lost. I won against American Family, but lost the claim against their agent, arising out of the 4 Mile Canyon Sunshine Fire in Boulder back whenever that was.
2010.
Before I had this much gray hair. But so they are tough claims. But if you think you have a legitimate claim against the agent, reach out to a lawyer and talk to him, her, it, and see what they recommend.
Yeah. So, okay, we have 3 final questions. One I'm not quite clear I get, but again, maybe the 2 of you can help me with this. Molly asks, when buying versus renting, apply in a similar or the same manner to renting dwelling policies. I'm not really sure. Oh, maybe, I'm not sure. I'm wondering if this person's asking, if you have a renter's policy, can you use the ALE to buy, maybe? Is that, I don't know if that's what you're asking, Molly. I don't think if you could, you know what, Molly, try using our Ask an Expert forum for that one. We'll see what we can figure out, maybe clarify it a little bit. So Paul and Deborah both of them have questions about underinsurance. So Paul's asking, who has the legal responsibility to ensure that the home insurance coverage is sufficient? Stating the obvious, we, the homeowner, have not been actively tracking the market price to rebuild a home in our location. Paul, you're really preaching to the choir here. I'm sorry to say. That is exactly the way we see it, is why would the layperson who goes to the professional have not be able to rely on the expertise of that professional who's getting a commission for procuring the insurance, right? What, isn't that their job to know how much insurance you should have? So I mean, but I think Tom kind of went over the answer of the legal responsibility.
Yeah, and yes, you're preaching to the choir. When John Q. homeowner goes and buys insurance, you have no point of reference unless you happen to be a contractor, but you have no point of reference, and the insurance company knows all the information. But every single one of you, I will almost guarantee it, if you read your policy and you read the little cover letter that accompanies or cover email these days that accompanies the renewal, somewhere in there it will say, or in both places, you choose the amount of insurance, not us. Even though, and somebody asked a question about an Allstate policy, and I've read the Allstate stuff as well, where they talk about it's not the term consumer price index, but it's something along that similar vein. And in one of them I saw where in the year before, the year before, so in 2021, they were saying, hey, prices are going down. I don't know what side of Mars they're coming from when they're making that comment. But right. In the same darn document, it says, but ultimately the choice is yours. And if you disagree with our number, bring to us another number and we'll give it consideration. So they cover their behind that way. And in the case that I had, that it was that provision that was front and center the whole time. And my client had a few other warts on that one, but you're hitting the nail on the head. But unfortunately, the agent does not have that legal responsibility presently, does not have the legal responsibility to try to accurately determine what are your limits. They should.
Yeah, and I just want to say, we've been saying this for years, the law doesn't reflect reality when it comes to whose responsibility it is to set limits in a home insurance policy, and the courts keep upholding this fiction. It's so ridiculous, that we, the homeowners, are the ones that set the limits. It's absurd. Yes, they can put that in there, just in their fine print, but everything else they say is the opposite, right? The ads are in good hands, you go to the agent, all that stuff. So, I'm on a team that's working on another legislative reform in Colorado to try to fix this, because we just haven't gotten it right. And we understand that, even today, people, Deborah, one of the last questions here, Deborah says, I don't understand how agents representing major insurance companies can have phone conversations where we say it doesn't seem like it's enough, and they assure you that it is, and then it turns out it's not, and you still don't have a remedy. But again, if you have that proof that you had that conversation with them, and you have that letter, you have that email, you have you're like, oh, I remember we refinanced and we had this conversation and they reassured me. If you have any kind of evidence like that, it can make a huge difference in getting the insurer to voluntarily retroactively reform your limits. And it's almost always going to happen behind closed doors. It's going to always require you to sign a confidentiality agreement. Don't tell your neighbors that we made this exception for you, but you got to have something tangible to show that conversation happened, and that they misled you, that you relied on what they said at a certain point in time. Molly did try to qualify her question. If we are underinsured with a rental dwelling policy and we cannot afford to rebuild, can we use the same process as a homeowner's policy to negotiate to pay out to buy a new rental property? So Molly, the property she owns and holds out for rent, not her primary home, got destroyed, right? She wants to, it's a rental income property. So she wants to know, can we buy a new rental income property instead of rebuilding? And that's a really good question. I don't know if anyone has ever asked that before.
I believe you certainly can.
I don't see why not.
You need to establish what the cost to rebuild that rental home is. And once you and the carrier agree as to that amount, that's what you're entitled to. So if you purchase something at or exceeding that amount, you should get the full value, even though you're underinsured. You should get your policy limit.
And the verbiage of the policy, and Chris pointed this out earlier, it uses the word replace. And there probably is no restriction in your policy about how they define replace. It doesn't probably doesn't say replace at the same site. It probably contemplates the potential of replacing somewhere else. That kind of verbiage is very frequently included in the policy. So don't let the carrier try to weasel their way out.
Right. Now, this is the very last question. And then we need to sign off. I want to let our generous volunteers get back to their evenings. And for those of you who may want to log on to the Survivor to Survivor forum, that'll be starting in a bit, and you want to have a little time off the screen maybe. Frank had asked what's considered to be soil stabilization. Is it part of debris removal, or is it part of building ordinance or cost of construction? My team mate Val already answered. It's part of the dwelling replacement. Work to be done after the debris removal to create a stable foundation for the home's foundation. And then Frank clarified that it was he was talking about a total loss. I think we probably answered that question. But is that anything there, Chris? Is soil stabilization is part of the dwelling coverage, not debris removal, correct?
That is correct. But so each policies are a bit different. So I've seen soil stabilization, I've seen land stabilization, but if it's one and the same, and it is to stabilize the land to rebuild, like for your foundation, oftentimes that's an additional coverage. And that's up, I mean, I've seen limits of $10,000. So that's an additional coverage if your policy provides it. So again, everyone's policy is key to their claim, and carriers are different. State Farm may have it, Allstate may not, but look at the policy. But to me, it's an additional coverage. And if you have a vendor, contractor, or somebody that established that that's a cost to be incurred, then it's properly something that you should seek as part of your claim.
Well, okay, that brings us to the end. Thank you so much to Chris, to Tom, Val, the Community Foundation of Boulder County that's providing the funding for us to be able to bring you this information. I just another reminder that tonight we have a Survivor forum starting at 8 o'clock your time, so half an hour from now. And those are free. We have another one on December 6th. And then on December 2nd, we will be having a financial decision-making clinic for Colorado wildfire survivors. So that's where we have financial planners. You can talk to them about tapping savings or things for underinsurance versus taking an SBA loan or a commercial loan. So and decisions of that nature, whether you want to, if you're still trying to decide if you want to buy or rebuild. So a reminder that we have our Survivor Speaks Tip series, our Ask an Expert forum, and our website. It's there for you 24/7. And for all of you who stayed on, thank you so much. And again, to my team, literally, like, we couldn't do it without you and your generosity, Chris and Tom. You've done it again. We answered many questions. Have a safe and pleasant evening, and we will see you all soon.
Good night, everybody. Good luck.
Good night.
Take care.